state charged you with 1 count of child sexual trafficking. That's a level 2 felony. Penalty is 10 to 30 years and fines up to $10,000. I have read the affidavit of probable cause. I do find probable cause for your arrest. I'll be entering a plea of not guilty on your behalf.
A 32-year-old Indianapolis mother stands accused of an unthinkable crime, attempting to sex traffic her own infant daughter for money. After a multi-agency investigation uncovered chilling messages, Morgan Stapp now faces 1 serious felony charge, and we're going to break all of this down for you right now. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Hey everybody, this is another Law&Crime legal alert. If you received Depo-Provera birth control shots and were later diagnosed with a brain or spinal tumor called meningioma, you may be eligible for a lawsuit. That's right, Morgan & Morgan is investigating claims that patients weren't properly warned about this risk. It's free to check, just takes a few minutes, and you don't pay unless they win. So scan the QR code on screen, click the link below, or go to forthepeople.com/LCDepo to see if you qualify. I really can't believe I'm saying this, but a 32-year-old Indianapolis woman is at the center of a deeply disturbing criminal case after being accused of attempting to sex traffic her own child, an infant, in exchange for cash. Okay? This is an allegation that sparked a multi-agency investigation involving the FBI and experts in child sexual exploitation. Court documents reveal these chilling details. This woman, Morgan Stapp, allegedly used social media to send explicit messages and a graphic offer attempting to arrange sexual access to her daughter for money, and she is now facing a charge of attempted child sex trafficking. Here's what we know so far. So the investigation began back in November of 2024 when the National Center for Missing and Exploited Children apparently received a tip regarding suspicious activity tied to a Snapchat account with the username Morgan_Stapp. And this brought the FBI in. And one particularly horrifying message allegedly read, "You can bleep her for $400. Half now, rest after, I'll send my address, I do live alone, and her dad is not in the picture." Now, when confronted by federal agents, Stapp reportedly denied the allegations and said that her account was hacked. But investigators kind of remained skeptical. And after the FBI brought in the Indianapolis Metro Police, who got a search warrant for the account, a forensic analysis revealed arguably damning evidence. The explicit messages were apparently traced back to near her address. And in total, authorities uncovered 81 very concerning messages that we're going to talk about. So Stapp was arrested. She was formally charged with attempted child sex trafficking under Indiana Code Section 35-42-3.5-1.3. Don't worry, I'm not going to ask you to memorize all that, but this is a level 2 felony. And the statute applies when, quote, a person at least 18 years of age knowingly or intentionally sells or transfers custody of a child under 18 years of age for the purpose of prostitution, juvenile prostitution, or participation in sexual conduct. Okay, before I go any further into the case, I want to bring on back here on Sidebar, fan favorite, one of our favorites, special guest, Marian Bracha, practice professor of law, director of LLM in trial advocacy programs, and a former child sex abuse and sex crimes prosecutor. Good to see you again. Thanks so much for taking the time.
Of course, Jesse, anytime.
How does the law differentiate between actual trafficking and attempted trafficking in cases, I was going to say in cases like this, I don't know if you've seen a case quite like these allegations, but actual versus attempted, that is an important distinction there.
It is an important distinction. The attempt is what we call in criminal law something called an inchoate offense. So things like attempt or conspiracy or solicitation requires a substantial step toward executing that crime, toward actually committing that crime. So the prosecution would have to show an intent. They would have to show what was in the defendant's mind, that she actually intended to commit this crime, and then that she took a substantial step toward actually committing it, even if it wasn't fully realized, if it never fully happened.
Is it a strength in the prosecution's case, the way this was built up? I believe it was first the National Center for Missing and Exploited Children, then the FBI, then local police. Each served a function in this to try to get a sense of what was going on here. If you have multi-agency collaboration, does that help a prosecution's case? If you're trying to visualize who they'll call as witnesses, how they'll explain this to a jury?
I think it helps. It can help in terms of the strength of the prosecution to show that there were resources available at different stages of the investigation. So the FBI certainly has resources or has equipment that perhaps local police wouldn't have or local investigative offices wouldn't have. And so to show that there was cooperation, to show that there was a strong chain of custody in terms of really looking into what pieces of evidence were developed and then kind of cross-referencing them and testing them at the next level of investigation, I do think that that is a strength in the prosecution. Of course, there will always be a claim of, or could be a claim of bias from the defense to say that, all of the law enforcement agencies were geared toward coming up with the same answer. But that would be something that would have to be surmounted with the testimony from the different representatives.
I hate to ask this, but how common are cases where parents or close family members are accused of trafficking or attempting to traffic their own children or family members? And I also have to imagine if that presents a unique challenge to prosecutors for a jury to accept this. I mean, we're going to talk about the digital evidence and whether the strength of that evidence, but is it a challenge to kind of present a case like this? Is it hard for a jury to accept this? Or again, maybe they'll accept it. The only thing that makes rational sense is their account must have been hacked, because how on earth could a parent actually do something like this? But I'm curious, in your practice, in your experience, are these common?
Well, they're certainly not as common, unfortunately, as some other forms of child abuse cases that we've seen and that you and I have talked about at length. Have I seen instances of trafficking of children by their own parents or by their guardians? Unfortunately, yes, it does happen. But remember, this is something that we talk about pretty frequently, that when there are crimes perpetrated against vulnerable populations, like children or like anyone, frankly, at the margins of society, they are what perpetrators consider to be, quote unquote, perfect victims because they are kept out of the limelight. And these are crimes that are committed in the privacy of one's own home, under cover of night, where there aren't witnesses and there aren't independent and objective people who will come forward and report it. So these things happen because no one is looking out for the marginalized and more vulnerable members of our community.
All right, I want to walk through how investigators piece together such a disturbing case of alleged child exploitation. And this is straight from the probable cause affidavit. So on November 1st, 2024, the FBI receives a tip from the National Center for Missing and Exploited Children that was submitted by a Snapchat company records custodian. And the report flagged alarming activity that was linked to a Snapchat account under the username Morgan Stapp. Now, according to the probable cause affidavit, quote, the report shows 3 photos of an infant and the text stating, "You can bleep her for $400, half now, rest after. I'll send my address. I do live alone," and her dad is not in the picture, like we mentioned before. Following the report, FBI agents interviewed Morgan Stapp on November 11, 2024. And during that initial conversation, she claimed she no longer had access to the Snapchat account in question. The affidavit reads, Morgan stated her Snapchat account was recently compromised and she no longer had access to it. Stapp reported to Snapchat a couple days ago, possibly November 2nd or 3rd. Now, Stapp told authorities that every time she tried to log into her Snapchat account, it stated her account was banned. And the affidavit also indicated that Stapp had received an email from Snapchat notifying her that the account was permanently banned for violating policies related to, quote, online commercial sex transactions. Now, when she was confronted with the username and the explicit messages that were sent from the account, or apparently sent from the account, Stapp denied responsibility, claiming that she had sold her old phone, bought a new one, had been unable to reset her Snapchat password, and she even reportedly claimed that she realized something was going on with her account when a man reached out to her on Facebook asking why she blocked him after he apparently sent her money. However, investigators quickly discovered apparent inconsistencies in her story. According to the affidavit, investigators obtained a search warrant for Snapchat's back-end data and traced multiple logins to the account from the same IP address and the same iPhone on multiple occasions. In fact, that same IP address was utilized on several dates: October 10th, 26th, 28th, 30th, and 31st. These logins seemingly contradict, or arguably contradict, Stapp's account of hacking. And according to the affidavit, pictures were recovered from the Snapchat account all after Stapp had claimed she lost access. So a screenshot of a PayPal account with the name Morgan Stapp and a picture of her, a screenshot of a pending Cash App from an account with a note saying $30 for baby formula, a selfie pic of Stapp in a car. And investigators also obtained a search warrant for Stapp's home, and they were able to identify the same wooden bed frames inside her home that had been depicted in one of the Snapchat videos. And even more arguably damning is that investigators uncovered more than 7,000 messages that were exchanged between October 29th and November 1st, 2024, a staggering volume of activity within just 4 days. And one recurring message appeared 81 times, reading, "Would you be interested in buying my nudes so I can get baby diapers?" Okay? During a November 22nd, 2024 interview with Child Protective Services, Stapp allegedly made also a pivotal admission. According to the affidavit, Stapp states she lied to the FBI agent about getting a new phone, and the phone currently in her possession was the phone she used to access Snapchat, stating, "I wanted the FBI to leave." So that confession, combined with the digital evidence that we're talking about and the Snapchat records, it led to her arrest. Professor, back to you. We were talking about this before we came on. From your experience, does this seem like a slam dunk case, or are there questions that weren't properly articulated in the probable cause affidavit that you say, I'm still not sold?
So a case like this centers around what we call ESI, electronically stored data or electronically stored information. And of course, that electronically stored information is the basis for a lot of prosecutions now in the age of AI, in the age of deep fakes, in the age where everything is communicated via cellular technology and digital technology. This is something that courts are very, very used to receiving. My concern with the evidence here is I would like to see a little bit more in terms of the record. So if the defendant claims that her account was hacked, that it was hijacked, that it was revoked as of October 18th or whatever the date was, I would want to see the correspondence from or with Snapchat indicating when that compromised date was. Perhaps it predates when these alleged messages were sent and the offer for trafficking of her daughter was sent. The other thing I'd love to see is ownership records of the Cash App account. I'd love to see ownership records of the PayPal account, because the version or the defense will always be that these accounts may have featured a photograph of this particular defendant. It doesn't mean that she had access, dominion, control, or ownership over these accounts to actually receive payments if in fact these payments were being remitted. So I think in that sense, the investigators certainly have put together a strong case. If I were the prosecution, I'd like to see more warrants executed and more records produced to show ownership and access to all of the devices and all of the accounts that are at issue in this case.
To be clear, if they can prove that she said, "I lied to the FBI," does that make everything else, does that confirm that she was operating that account and sending this money or trying to receive this money? Or does that suggest, hey, she might have lied to the FBI or admitted she lied to the FBI, but that doesn't confirm all of the digital evidence? Or do we treat it as two separate things?
No, I like that question. I like how you phrase it, because you give me a chance to talk about my favorite rule of evidence that we were talking about before we started filming as well. There's a concept, there's a legal concept in evaluating credibility, which is false in one, false in all. And that's why the jury is so important in our system, because it is entirely up to the fact finder in a criminal trial to determine who they believe, what witnesses they believe, and how much they believe from those witnesses. And so it's completely up to a jury to say, you know what, this person admitted having lied on one occasion. That colors the rest of their testimony or the rest of their version of what happened. So we're going to disregard everything else they say happened. Or they could say, it's completely within the jury's purview to say this person may have lied about this one specific thing. Anybody would be unnerved to be interviewed by the FBI or to be the subject of a very sensitive investigation like this. We could understand why she would have been less been honest in this regard. But gee, we don't really think that she lied about everything else in the investigation. I'm not saying that that's what a jury would find. I'm saying that that is within the jury's purview to say we either believe her entirely, we don't believe her at all, or we believe bits and pieces of what she said in the midst of this investigation. However, there is a powerful rule of evidence that says if there is evidence of a dishonest character, if this defendant chose to take the stand and testify in her own defense, the fact that she lied on a previous occasion could be used to show that she is someone of dishonest character, of untruthful character. And that could also be used by the jury to weigh her credibility and consider her a dishonest or an incredible witness.
By the way, how common is it for social media companies like a Snapchat to identify and report suspected child sex trafficking, exploitation, abuse to law enforcement? Is it common? Do they have a legal obligation to do so?
I believe they are mandatory reporters. I believe there is a requirement that if there is subject matter like this, that it's flagged, that it's required that they report it to law enforcement.
Yeah, and I mean, obviously, if these allegations are true, thank goodness that they did, because we wouldn't be talking about this probably. The volume of messages, too. Let's just talk about that. The volume of messages, the digital communication, 7,000 messages. How does that affect the analysis?
Well, again, I'd want to see the records. I think we have to see who this defendant was purportedly or allegedly talking to, what kind of messages were being sent. You know, several years ago, there was a statistic that millennials were sending something like 1,500 texts a month, and that seemed really outrageous and over the top. I think that's pretty average, if not below average at this point. So if this Snapchat account was the only means by which this defendant had of communicating via text message or via direct message, then maybe it's not that extraordinary a number. But again, I'd want to see with whom she was communicating, how often, and what the subject of those communications were.
Now let's talk about something else. So during her initial court appearance on July 11th, Stapp identified herself as a stay-at-home mother of 7 who relies on public assistance, gig work, and help from her parents. Take a look.
And what do you do for a living?
I stay at home and take care of my kids.
Okay. So you're a stay-at-home mom?
Yeah.
How many children do you have?
7.
You have 7 children?
Yes, ma'am.
Okay. Are you married?
No.
All right. How do you support yourself?
I get help from my parents. Government sends assistance. On the sidelines, I use my mom's DoorDash account. I created an Instacart where you go shopping and you deliver.
Okay.
But that's what I do for money.
And the court also heard that Child Protective Services removed her children from her care in December of 2024, and Stapp said they were just returned to her in June, so just 1 month before her arrest. And this came up when she was asked about her recent work history.
I have not worked in quite some time since DCS removed the kids in December. I fell in a deep depression.
Okay.
I just got the kids back a month ago.
Okay.
Now, given the severity of the allegations, the judge set Stapp's bond at $200,000 surety, issued a no-contact order for 2 of her children. Professor, that's common, right? So first of all, what are we talking about when we say a $200,000 surety bond and a no-contact order? That means you can't not even be near the children. You can't communicate with them in any way, right? So just if we can break down those 2 points.
Right. I think the no contact order is intended to protect any undue influence that the defendant may have or may try to have with the witnesses to try to influence their testimony. Now, if we're talking about an infant child, of course, there's not going to be any likelihood of that child testifying in open court. But that really is the objective of that no contact order, to protect the witnesses from undue influence, to change their testimony or not participate in the prosecution.
Obviously, she's innocent until proven guilty. However, I have to ask, these socioeconomic factors, if we're talking about relying on public assistance, gig work, struggling with money, how does that affect cases involving alleged child sexual exploitation like this? Is that something that is common in these cases? Is that something you'd be looking out for? Would it be used by prosecutors in a case to explain why she allegedly did this?
I think the prosecutors have to be very, very careful with evidence like this. And I think, quite frankly, as legal commentators, need to be very, very careful with this evidence as well. The last thing we want is to criminalize being poor. and to say that a motive to commit crimes is because someone is poor or reliant on public assistance. So I think if there was a very finite universe of evidence to show that this person had fallen on hard times, that there was an immediate need for funds, and that's what gave her the motivation to post an advertisement like this, perhaps. But again, if I were the prosecutor, I would tread very, very carefully and very, very lightly around that, not only to not scare away the jurors and perhaps turn off the jurors and lose credibility in the eyes of the jurors, but also to avoid any potential appeal issues.
What about Child Protective Services apparently removing her children in December of 2024, returning them in June of 2025? We don't know exactly what that had to do with and why that happened, but how does that factor into the prosecution?
Well, that could factor into the prosecution, but again, that would trigger another rule of evidence that we could talk about, which would be other bad acts. So it very well could be that there were other instances, that there were other concerns completely unrelated to this Snapchat investigation that caused the defendant to lose custody for a certain amount of time. What we call propensity in the law means that an argument would be made that just because someone did something bad or wrong on one other occasion cannot be used to prove that they must have done this bad or wrong thing on this instant alleged occasion. And so, again, the prosecutor would have to be very, very careful not to argue that because the defendant did something bad or wrong previously, that they must have done something bad or wrong in this particular case. That's called avoiding the propensity argument. If they can tailor it, if they can show that there is an acceptable use of that evidence, it would be up to the judge whether or not to let the jurors hear it.
If these allegations are true and Child Protective Services returned the children back in June, do they face any kind of important questions? Or is this a case where whatever the reason was that the children were removed, if it's really not connected to the allegations now, we can't always, hindsight's 2020. It's hard to judge them for doing that. I mean, how should we be thinking about Child Protective Services?
I always think about all of these agencies as totality of circumstances, right? So how much information was available to the service agency? How much was available to the social workers who were supervising this particular case? Should they have known that returning the children would have exposed them to the same or perhaps even worse conditions than when they were removed? And so we're always considering what the totality of the information was and what could have been made known to the social service agency and to the particular workers who were involved in this family's care.
So it's been reported that a pretrial conference has been scheduled for September 15th, 2025. A jury trial date has not been set as of yet. When we talk about a pretrial conference, we talk about next steps. What should we be looking out for? What do you think is going to be happening there?
I would anticipate that there would be some defense motions, perhaps a motion to quash the complaint, perhaps looking for some additional ESI, that additional electronically stored information that we talked about previously, other records requests to prove the ownership or the access of the PayPal accounts, the Cash App accounts, who and where the Snapchat account was being accessed before these messages were being sent to show some consistency in usage. So I would anticipate some defense motions pre-trial and for additional records, if not motions to quash the complaint entirely for lack of those records.
Professor Marian Bracha, thank you so much for coming on. Really, really always value your expertise in not only this case, but every case that we cover. One of the best. Thank you so much. Really appreciate it.
Thanks, Jesse.
And that's all we have for you right now here on Sidebar. Everybody, thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. I'm Jesse Weber. I'll speak to you next time.